A reasonable accommodation is a modification or adjustment to a job, the work environment, or the way things usually are done that enables a qualified individual with a disability to enjoy an equal employment opportunity.
An equal employment opportunity means an opportunity to attain the same level of performance or to enjoy equal benefits and privileges of employment as are available to an average, similarly situated employee without a disability. Reasonable accommodations must be provided to qualified employees regardless of whether they work part-time or full-time or are considered probationary. This video will provide you with information about reasonable accommodations.
The Americans with Disabilities Act, ADA, requires reasonable accommodation in 3 aspects of employment: to ensure equal opportunity in the application process, to enable a qualified individual with a disability to perform the essential functions of a job, and to enable an employee with a disability to enjoy equal benefits and privileges of employment.
Employers are not required to provide accommodations that are primarily for personal use or involve personal services, such as wheelchairs, hearing aids, toileting, or clothing management. An employer does not have to provide the preferred accommodation as long as the accommodation provided is effective. Employers should engage in the interactive process with an employee to understand why specific accommodations are requested and explore a wide range of options to meet the accommodation requested before denying an accommodation or providing something other than what was requested.
Examples of reasonable accommodations include, but are not limited to, making existing facilities accessible, job restructuring, part-time or modified work schedules, including leave, purchasing or modifying equipment, changing tests and training materials, modifying policies, providing qualified readers or interpreters, and reassignment to a vacant position.
An employer is not required to provide a reasonable accommodation if it would cause an undue hardship. This means a significant difficulty or expense specific to the employer resources and circumstances. This may not only be financial difficulty, but also relate to accommodations that are unduly extensive, disruptive, or those that would fundamentally alter the nature or operation of the business. This should be assessed on a case-by-case basis.
For additional information about reasonable accommodation under the ADA, see Reasonable Accommodation and Undue Hardship online.